All right, today we're diving into a really tricky corner of Turkish rental law. Think of it like a high-stakes maze. What do you do when you have a tenant who pays the rent, but they're always late? It's a process where you have to be absolutely perfect, and we're going to map out every single turn for you.
So let's just kick things off with this scenario, because I know it's one that drives a lot of landlords crazy. Your tenant, they're not a deadbeat. The money always shows up, eventually, but they're consistently late, and that messes with your own finances. Not to mention, it's a breach of your agreement. So what's your move? What can you actually do?
Well, before we get to the answer, you've got to understand the playing field. Turkish rental law at its core is built to protect the tenant, and that means you can't just kick someone out on a whim. Eviction isn't about who's got more power. It's more like a game of legal chess, where every single move you make has to be precise and calculated.
And that brings us right to the heart of our issue today, the late-paying tenant puzzle. It's a special kind of problem because, well, the usual tools you'd use for a tenant who just flat out doesn't pay, they don't really work here.
The solution is this very specific legal tool. It comes from Article 352/2 of the Turkish Code of Obligations, but everyone just calls it the two justified warnings rule. Now, the key word here is habitually. This isn't for a tenant who has a one-off slip-up. No, this is designed specifically for that chronic, frustrating pattern of always paying late.
To really get just how powerful this tool is, we need to see how it stacks up against the more standard eviction process. It's really a tale of two completely different legal strategies.
Okay, so look. On the left, you've got the standard procedure for non-payment. You give the tenant a 30-day notice, and if they pay up within that time, well, the problem's solved, and your right to evict on that issue is gone. But our tool, over here on the right, it's a totally different beast. It targets the habit of being late. So when you send a warning, it doesn't matter if they pay the next day. The payment doesn't make the warning disappear. The lateness itself is the violation, and that changes everything. So, how do you actually use this thing? Well, get ready. It's not a simple one-step process. It's like a gauntlet. You have to fight your way through 4 critical conditions, and trust me, each one is packed with hidden traps.
First up, timing. And folks, this is an absolute deal breaker. You need 2 warnings for 2 different late payments, and here's the kicker, they both have to be sent within the same rental year. And be super careful here. A rental year is not January to December. It's the 12-month clock that starts on the day your lease was signed. You get this wrong, and your case is dead on arrival. Okay, condition number 2 is all about the warning notice itself, the form. And every little detail has to be perfect. It has to be a formal written document. If you co-own the property, both landlords have to send it. If you have 2 tenants on the lease, both of them have to get it. And the content, crystal clear. You have to state the exact month and the exact amount of rent that's overdue. Any sloppiness here can get your notice thrown out. Now here is where our modern habits can absolutely sink us. You might think a quick WhatsApp message or an email is efficient, right? Wrong. Legally, it's a fatal error because you can't prove without a shadow of a doubt that they received it. To be safe, to be legally bulletproof, you have to use a method that gives you undeniable proof. The gold standard is sending it via a Notary Public. Registered mail is a decent backup. And here is another huge trap, the content of your warning. It is so tempting to lump everything together, right? But for this specific process, you absolutely cannot. This eviction path is only for the core rent payment. If your notice starts demanding money for utility bills or building fees or repair costs, it's immediately invalid for this purpose. That one simple mistake completely neutralizes your warning. All right, condition 3. This is really the heart of the matter. Your warning must be justified, or haklı, as they say in Turkish. Now, what does that mean? It means that at the very instant you sent that notice, you had an undeniable, legitimate legal reason to do so. It's not just about the tenant being late. It's about your action being legally sound at that precise moment. But this whole idea of justification is what leads us to the single most mind-bending, counterintuitive, and critical pitfall in this entire process. You could say this is the final boss of the eviction maze. It's called the payment before receipt doctrine. Now, this isn't a law written in a book somewhere. It's a very strict rule that comes from Turkey's highest court. And the rule is simple and absolutely brutal. If your tenant pays the rent they owe before your official warning notice physically arrives at their door, your warning is considered unjustified. It becomes legally worthless.
let's just walk through how this plays out in real life. On January 4th, you go to the notary and you send your warning. The next day, January 5th, your tenant, who has no idea a notice is coming, goes to the bank and pays the overdue rent. Then, on January 6th, the delivery person from the notary finally shows up and hands them the notice. You've started the legal process, but guess what? You've already lost.
And the result? Your warning is not justified. It's useless. Because the payment on the 5th happened before the receipt on the 6th. You've been beaten, not by a legal argument, but by the speed of a bank transfer versus the speed of a delivery guy. It's a race against time. You'd think modern technology would help here, right? Well, nope. Using Turkey's official electronic system, E-Tebligat, actually makes this problem worse. Legally, a notice sent that way is only considered received at the end of the 5th day. That creates a 5-day grace period for the tenant to pay you and kill your wording before it's even legally arrived. So the strategy is simple. Don't use it for this. Speed is everything, so stick with a notary. So, let's say you've done it, you've navigated every trap, you've dodged every bullet, you have your 2 perfect justified warnings in your hand. You're almost there, but you're not done yet. Now you have to enter the final all-or-nothing sprint to the finish line.
1 month.
From the moment your rental year ends, you have exactly 1 month to file that eviction lawsuit. And I have to stress, this isn't a suggestion. It's what's called a forfeiture period, which means the deadline is absolute. There are no extensions. If you miss it by a single day, your 2 perfect warnings turn into worthless pieces of paper, and your right to evict on these grounds is gone, forever. So here's your final checklist for the courthouse. You're going to file at the Civil Court of Peace in the same district as the property. And you need to walk in there with your entire arsenal of proof. The lease agreement, both of your warning notices, the official proof of delivery for both notices, and the bank statements to prove the whole timeline. So when you boil it all down, it really comes down to these 4 pillars of success. You've got to nail the timing, 2 warnings inside 1 rental year. You have to perfect the form, the right method, sent to the right people. You need solid justification, it's for rental only, and you won that race against time. And finally, you have to hit that ironclad 1-month filing deadline. If any one of these pillars crumbles, the whole thing comes crashing down. You know, at the end of the day, what this all really teaches us is that success here has nothing to do with being powerful or being right in a moral sense. It's about flawless technical precision. It's a procedural challenge where the winner is simply the person who followed the incredibly specific rules perfectly. Which really leaves us with a final big picture question. A legal system that demands this level of precision, is it a fair way to protect tenants from being thrown out too easily? Or is it an impossibly frustrating puzzle for landlords who are just trying to enforce their contract? I think the answer probably depends entirely on which side of that lease agreement you're sitting on.